Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And friends, welcome back. We are in Calloway County, down here in Murray, Kentucky, speaking to attorney Jeff Roberts, and we're going to discuss 5 common misunderstandings that injured workers often make or have when it comes to their workers' compensation claim. Jeff, good to see you, guy.
Good to see you, Jim.
Always love coming down here. You've done workers' compensation claims for over 30 years now throughout Kentucky.
I'm working on my 32nd year practicing workers' comp claims.
So I would think in that time you've spoken with obviously a lot of different clients. And it's interesting because this may be their first claim, and they're not really sure how it works, not sure, what's different about a workers' comp claim versus an injury claim that might be, like a car wreck or something like that. So you've kind of encapsulated a list of 5 misunderstandings that are pretty basic. So let's kind of jump into that one. One of them talks about, do I have to really tell my work, my company, my employer, or should I kind of keep that to myself?
Right. Several times I've talked to injured workers who did not report the injury because of fear of reporting it. And it's a misunderstanding from the standpoint of should you or should you not report that injury. And some people think they should not report the injury because they have fear of some sort of retaliation. If they report the injury, then the employer could retaliate against them because they suffered an on-the-job injury. I've talked to some who were fearful that they would get fired because they had a work injury. Others thought, well, when raises come around, I'm not going to get the raise because I've had this work-related injury. So if I report the injury, it could affect my raise or affect my employment or even affect promotions.
Or even, the ability to take on some overtime hours.
Exactly, overtime, exactly. They think it's going to affect their pay in some form or fashion a lot of times in that regard. And so they don't report the injury. And there's a couple of problems with that. One of the first and one of the main problems is Kentucky's workers' comp law requires an injured worker to notify their employer of the work-related injury. You have to give due and timely notice of the work-related injury. Now, that doesn't mean that you have to give notice within a 24-hour period of time. I've had some clients come into me that worked at factories that had a company policy that work injuries had to be reported within 24 hours, and if you didn't, then they weren't going to take it as a workers' comp claim. They weren't going to pay workers' compensation benefits. And so I've had clients come in and say, well, I didn't report it within 24 hours because I didn't really think it was that bad. I thought it was just a minor strain. Sleep it off the next day or 2 days, it'd be gone. And over the weekend, it wasn't any better. And then I tried to report it on Monday, and they said it's too late. That's not what Kentucky law is. So if you have a reasonable basis for not timely reporting, then that is allowed for a report. And there's no set time frame, frankly. If you report within I've never seen a case where the report was within the first 7 days or even first 2 weeks that the judge didn't say that's due in timely reporting of the injury. There is one case that went up on appeal that it was more than 6 months later, but it was the situation where the person lifted something heavy. They had later that day their back started aching a little bit, and they thought it would go away, and then went to the doctor, had some therapy, still thinking it was going to get better. And when they found out they were going to have surgery, that's when they reported it. And the court basically said that was a legitimate, they didn't think it's anything permanent. It was a temporary injury. They reported when they found out that it wasn't going to be just a temporary injury. So you have time to report it, but if you fail to report it, for a long period of time, that can be very, very problematic. So you do need to report the injury. Even if it's a minor injury, tell your supervisor about it so that you have reported it. And that's
the law. That's the statute right there. It's you really should report it up the chain
right
when it happens as soon as you can.
Exactly. And, you don't have to go up to, the main head office to report it up at HR. That's not what the law requires. The law requires that you report it to your employer, and as long as you report it to your superior, your foreman, your supervisor, whatever they call it at wherever you work, as long as you report it to that person, if they fail to report it up the chain, that's not your problem. That you've reported it to your supervisor or your superior, and that's what you're supposed to do. And so from a legal standpoint, you're fine at that point in time. And the other misunderstanding in this regard is that they are legally prohibited from retaliating against someone for having a work-related injury or pursuing a workers' compensation claim. The statute is very clear. If you have a work-related injury and you report that work-related injury, they cannot retaliate against you in regard to the hours you work, the pay you receive, terminate your employment, or any sort of retaliation because you reported a work-related injury is a violation of Kentucky law. KRS 342.197 specifically prohibits any retaliation, and that can give rise to not only the workers' compensation claim, but a civil case against the employer that, frankly, in all likelihood, could be very much more valuable than the workers' compensation claim would have been in and of itself. I've done this for 32 years, and I've seen employers not really retaliate, but kind of encourage someone not to pursue or file a claim or something of that nature, but they don't take any retaliatory action. It's very rare that retaliatory action occurs because that law is in place and
it's got teeth.
It's got teeth to it, and because not only can you file the civil suit, but the Department of Workers' Claims can come in and investigate and also issue fines as well for that. So there's teeth to that. To that retaliation statute in the Workers' Compensation Act. So you don't have to worry about that, or you shouldn't have to worry about that. But if it does occur, call me up and we can deal with that as well from that.
And let me ask you something. You said you've got to talk to your supervisor. It doesn't necessarily have to be your direct supervisor. It could be a supervisor in a different department. Let's say you can't find your guy. But some superior, somebody kind of a level up on the food chain, right?
Yes, a level up. Yeah, somebody that is above you at the plant now, and so you've just got to tell that person. And if your superior, your supervisor's not at work that day, or is not available, if you're going to report it right after it occurs and they're not available, but there's a supervisor on the other line close to you, you can go tell them. That's fine. And it doesn't have to be in writing. Verbal notice to the employer is sufficient. You can get into proof issues there. If the supervisor said, no, he didn't tell me, then you got a he said, she said type situation. But normally the supervisor does pass it on up the chain from that standpoint. So usually that's not an issue there. But as long as you've reported to your supervisor, you're good. Or to someone above you in the facility, then you're fine as far as giving proper notice.
That makes a lot of sense. Now, the second misunderstanding that we're going to cover today deals with the company trying to tell the injured employer where they need to go for treatment. Some of them may have on-site, like a medical facility on-site or in the plant. Others may say, well, we want you to go see these doctors, here in the next town over or whatever. They try to direct that. They can't really do that, can they? They
cannot. Some companies will try to get you to go to the company doctor, so to speak, the doctor they handpick to treat your condition. And they're not, they cannot tell you what doctor to treat with for a work-related injury. Now, there are plants and employers that have like nurses stations at their facilities. General Tire, when it was around, had a plant nurses station. I know Pilgrim's Pride has a plant nurses station. General Motors has a plant medical facility, and several plants have a plant medical facility or a nurse there that they kind of want you to go to if you had an injury or something of that nature. And there's no problem with going to them and saying, okay, I've had this injury. And that can be someone that you report the injury to. To be honest with you, if they do, you can go to them and say, I cut my arm on this, or I lifted this box and now my back's hurting, and you can report it to them, and that's going to be doing timely notice as well if it's within the proper time frame from there. But they cannot tell you, okay, well, you have to have our permission to see a doctor. There's one plant that does that. Tries to do that, or you've got to go to this certain doctor to treat, and we're not going to pay. If you go to somebody else, we're not paying.
It's not really up to them.
It's not really up to them. And I've had, in fact, in one case several years ago, a plant that did that, and they gave my client a little sheet of paper that had all of these things, and one of them on there was, if you go to a doctor without us approving it or us telling you it's okay to see that doctor, and it's not somebody we told you can see, then we're not going to pay the medical bills. In that case, they ended up paying the medical bills, and they ended up paying my client's attorney fees because of their unreasonable actions in that case. So the law is very clear that the injured worker gets to pick their medical providers. And in Kentucky, medical providers is worded very broadly on what's considered a medical provider. It's not just the doctor you go to, but there's a Supreme Court case directly on point. In fact, I was party to the case. I was one of the attorneys that argued this matter to the Kentucky Supreme Court. A pharmacy is considered a medical provider, so they can't tell you, you got to use this pharmacy. You can go to the pharmacy that you normally use or that you want to use for your work-related medications, medications for your work-related injury. If you need diagnostic testing, if you have to have an MRI, I've had insurance companies try to send my client that lives in Murray, Kentucky, all the way to Hopkinsville for an MRI because they could get it $200 cheaper in Hopkinsville, but my client had to drive the hour to hour and a half up to Hopkinsville and then drive the hour and a half back, and they didn't want to pay them mileage or anything else or their time for doing that. And I've told the insurance company, you don't get to pick. There's MRI facilities here in Murray. My client's going to go to one of those. And never really had much pushback, but I've had clients who've driven a long way. I've had one that was sent to Nashville for an MRI, which didn't make any sense to me whatsoever, but that's what happened. That was before I was involved in the case. Physical therapy is the same. You get to pick where you go to physical therapy. Any medical provider, you get to choose. Under Kentucky law, you get to choose. There's one caveat to that, and that is some employers have a managed care plan, and they're allowed to have a managed care plan for workers' compensation claims in Kentucky. If they have a managed care plan, then you have to use a doctor within that managed care plan. They can't tell you which doctor, and they have to have a choice of doctors within that managed care plan. But you get to pick, and they have to provide you a list of the doctors. Either they, if you have access to the internet, they can say, here's where you can go access these by county or whatever on the internet. Or if you don't have access to the internet, you can say, send it to me, in the mail. So, but they're required to provide you a list of the providers within your area, geographic area, that you can see for that, and then you get to pick among those doctors that are in that managed care network on which one you want to see. So they can't say you've got to go to this doctor, but they can say these are the doctors you have to choose from if they have a managed care network. But they have to have a managed care network approved by the Department of Workers' Claims before they can do that.
And in all reality, most employers don't have that. That's a specific few that probably do.
There's a few that do, but not many.
Yeah. Now, Jeff, I want to come back to something. A few weeks ago, we recorded in episode 68 an episode talking about the designated physicians form, which is form 113. And that's where you're actually, as an injured worker, going to say, this is going to be the physician I want to see. So if you do go to, let's say you go to the company medical, or you go to somewhere where they've initially said that, be careful of the papers you're signing, right?
Correct.
Because they may try to sneak something like that in there.
Exactly. And if you go back and listen to that episode, one thing I said in there is you get to pick that designated doctor. You get to change that designated doctor one time, and then after that, any change has to be approved by the insurance company. And I've seen frequently, I've had clients come into me, and the doctor that they've that is on there that they signed the form for was the company doctor that they sent them to right off the bat, and they went to instead of going to their family doctor. And if they've done it and they haven't made the change, that's fine. We can change to the family doctor, their family doctor then if the family doctor is willing to do that, or change it to another doctor. But what I've had occur is they've gone to the company doctor who's a family doctor, then the company doctor referred to a specialist, and then they have them changed to the specialist, who's also the company specialist in that regard, and then changing at that point can be very, very difficult to do because the insurance company is not going to agree for you to go see somebody besides the company doctor. And when that occurs, it kind of ties our hands to some extent from that standpoint. So, before you sign any documents that the insurance company is wanting you to sign, you need to talk to an attorney beforehand.
Exactly. And friends, if you're listening to this episode, in the show notes, which is all of those paragraphs below where you're actually listening to this episode, I'm going to put a link back to episode 68. You can also go to Jeff's website, jeffrobertslaw.com, and go to the podcast tab, and you'll be able to find it right there as well. But that's a really good episode to kind of keep you out of some hot water there. Jeff, let's transition then to the third misunderstanding, which deals with returning to work.
Yes. A lot of people think that if they pursue a workers' compensation claim, I've had people come in to see me or talk to me while they're off work after an injury. And the doctor hadn't released them. They haven't reached maximum medical improvement yet, and they don't want to pursue the claim because they're fearful that they're not going to be able to return to work. If they pursue a claim, then they're saying they're disabled and they cannot go back to work and do the job that they want to go back to. Most workers, the vast majority of injured workers, want to get back into the workforce. And in fact, the ones who can are usually very upset that they cannot get back into the workforce. And in Kentucky, you can have permanent partial disability. And the amount you receive permanent partial disability means that you have some disability, you're not totally disabled. Kentucky goes by an impairment rating system for partial disability, which if you've never been involved in workers' comp before, you have no idea what an impairment rating system is because that's about the only time it's used. But if you have an impairment rating under the 5th edition of the AMA Guides, you have a claim for permanent partial disability, even if you're back at work doing the exact same job, making the exact same money you were before. You're entitled to some permanent partial disability if you have an impairment rating. Obviously, if you're not back at work, if you're not able to earn the same or greater wage, if you got to do a lot less physically demanding job that doesn't pay as much, then what you get under workers' comp increases in that setting, but you're still entitled to permanent disability benefits. And pursuing a claim for permanent disability benefits does not preclude you from going back to work. And again, we get back to what we talked about on the first issue, and that is they cannot retaliate against you for pursuing a workers' compensation claim. So if you're pursuing a permanent disability claim, if the doctor releases you to return to work without restrictions, they can't say, well, we're not going to bring you back to work because you're filing a workers' comp claim against us. If he releases you to return to work with restrictions, but those restrictions doesn't prohibit you from doing your job, they can't say we're not going to bring you back to work because you have these restrictions, even though you can do the essential functions of your job because the Americans with Disabilities Act prohibits them from doing that. So pursuing the workers' compensation claim does not or should not have any effect on your ability to go back to work or return back to work and do the job if you can physically do so.
That makes a lot of sense. And it's one of those things that there's a lot of games that get played, whether it's the company, the employers themselves kind of misdirecting a little bit, or whether it's the insurance adjuster who's actually representing the company. A lot of games are played. And the more we do this, I mean, we're literally recording episode 72. We've talked a lot about workers' compensation, and I'm just amazed at such a disadvantage that the injured worker finds himself or herself at this point in the game.
Yeah, and I have people ask me at times from the employer side as well as workers at times, why, if I'm able to go back and do the same job, making the same money, why am I entitled to any disability benefits? And the reason for that is the study showing, statistically speaking, people who've had an injury, whether the injury's on the job or off the job, people who've had suffered injuries have a decreased work life. You don't work as many years after an injury as someone who's uninjured does. So your total earnings ability is reduced by a work-related injury, or if you had the exact same injury from a non-work-related event, it's going to be the same kind of reduction that you're going to have. It doesn't matter where the injury occurs; it's the fact that you had the injury that decreases your work life. And injuries, some injuries can, even though you can return to work now, they're expected to get worse over time, and so your earning capacity, not just your work life, but your earning capacity can go down into the future. And so what the law says is we'll compensate you somewhat now for that, because we know that statistically speaking, this is going to affect your earnings in the future as well.
And to clarify, the injury that you've sustained has to be work-related to begin with to qualify for workers' comp.
To qualify for workers' comp,
you were talking in general injuries, either inside or outside.
Exactly, and talking about affecting work life and affecting earning capacity, it doesn't. If you lift a heavy box at work and herniated disc and have low back surgery, that's going to have an effect on your earning capacity and your work life. If you lift the box at home and have the exact same injury, it's going to have the same effect. So where the injury occurs doesn't make a difference on the effect on future earnings and work life. Where the injury occurs makes a huge difference on whether it's a workers' comp claim or not a workers' compensation claim.
In fact, the insurance company is going to try to prove, you didn't get hurt at work. That's something you did at the softball game or whatever, or mowing the yard over the weekend or whatever.
They're going to do their best.
Absolutely. And so will you, luckily. So,
yes.
Okay, so let's transition to the fourth misunderstanding, which is dealing with medical bills and how to get those paid.
Yeah, in frequently when a person is injured on the job, especially, when it's an injury that is, an immediate injury. You lift a heavy box, have sudden sharp pain, go down to your knee, tell your supervisor you got to go to get emergency room or to urgent care that day, and start the treatment process. Frequently in those type of settings, the workers' comp insurance will start paying the medical bills. There's no problem with them paying the medical bills. And then the worker thinks, okay, well, even if I don't pursue this claim, they're going to continue to pay my medical bills for as long as I need medical treatment for this injury. And, it doesn't matter how long this bothers me, they're going to continue to pay my medical bills for that. And so there's no reason for me from a medical bill standpoint or treatment standpoint, no reason for me to go, for me to pursue a workers' compensation claim. And that's not true. When you've suffered a work-related injury or work-related occupational disease, because that's also a workers' compensation claim, there are deadlines for you have to file the claim within. And if you don't file the claim within those deadlines, then you're barred from pursuing the claim at that point in time. It's called a statute of limitations. Statute of limitations for an injury is, as a general rule, 2 years from the date the injury occurs. There are some there's some things that can extend that. If you receive benefits for being off work called temporary total disability, that can extend the statute of limitations. For an occupational disease, generally the statute of limitations is 3 years in those. But once that statute of limitations has expired, they will stop paying your medical bills. The workers' comp insurance company will, once they realize that the statute of limitations expires, they're not going to pay another medical bill for you at that point in time. It's extremely rare that they pay medical bills after the statute of limitations has expired because they don't have to anymore. Whereas if you pursue the claim, if you resolve the claim successfully, either by settlement or by a judge's decision, then your medical will continue for a minimum of, if you've had a permanent injury, it'll continue for a minimum of 15 years, potentially lifetime. It depends on the severity of the injury, on how long the medical will continue, but it's going to be a minimum of 15 years that they would have to pay for reasonable and necessary medical associated with that work-related injury. So that can be very, very important, because if you've had an injury to your joint, pretty much any joint in your body, and the spine is a joint, if you've had an injury to any joint, the likelihood of developing arthritis increases. That's what I've been told by doctors. And if if you injure your knee and there's no arthritis or very mild arthritis, and then 5 years later you got real severe arthritis in that knee, and the doctor says it's because of that injury you had 5 years ago is the reason your arthritis is as bad as it is, and we need to do surgery. Workers' comp should cover that if you've pursued the claim successfully, either by settlement or judge's decision. If you let the statute of limitations expire, workers' comp is not going to cover it, and at a minimum, you're going to have to pay co-pays and deductibles if you have health insurance. If health insurance says this is from a work-related injury, nearly every health insurance contract I've ever read says we don't cover work-related injuries, and I think it's an unclear question on whether health insurance would have to pay once the statute of limitations is expired. I would argue they do, but I've never known a court to address that issue, and frankly, I wouldn't want to be the injured worker that has to fight that battle, and to try to get my health insurance to pay for this $40,000 surgery when they're saying no, workers' comp should have, and you let the statute of limitations expire.
And friends, I'm going to refer you to another podcast episode that we did. This was episode 55. Where we specifically did a deep dive, a good probably 30 minutes on the statute of limitations. So if you're interested, I'll put another link in the show notes about that specific issue. So Jeff, we're about to wrap up the podcast episode, but we have one more common misunderstanding, and that has to do with attorney's fees. Wow, hiring an attorney to represent me is just going to be too expensive.
Exactly. People frequently, of course, the first visit with me is free. The initial consultation doesn't cost anything. If you don't hire me, you're not out anything from that standpoint. But I get asked that question frequently, or people say, well, I can't afford an attorney. And I have to explain to them that I work on a contingency fee basis. That means that I get paid at the end of the case when I put money in my client's pocket. I don't get paid if I'm not successful in the case. I don't get paid an attorney fee in that case. If I am not successful, I also don't get reimbursed my expenses. And we've covered the contingency fee and the reasons for contingency fee and how that is in episode 56. So hopefully Jim will put a link to that episode if you want to go into that a little more and do a little more deep dive on what a contingency fee is and why those are helpful. From there, in a workers' compensation claim, a lot of people, when they think of a contingency fee, they think of what's charged in a car wreck case. And generally in Western Kentucky, the standard fee for someone involved in a car wreck case on a contingency fee is going to be 1/3 of the recovery, or some attorneys have gone up to 40%. I still only charge 1/3 of the recovery on a car wreck, but I know some firms have gone up to 35% or 40% of the recovery in those type of cases. In a workers' compensation claim, I only charge 20% of the recovery at max. Sometimes it's even less than 20%, but I never charge more than 20% of the recovery from an attorney fee standpoint in a workers' compensation claim. So, and frankly, if you go and look at some of the statistics that have been done in the past, someone with an attorney involved is going to recover more money. And frankly, as generally, if you have an attorney representing you, the recovery that you're going to receive is going to offset the attorney fees you paid. You're going to put more money in your pocket than you would have without an attorney involved in that case. But even there, if you're still not sure, and that's fine, I understand. Coming in to talk to me about the case, it doesn't cost you anything. So you can come in and have that initial consultation anyway, and then make the decision after you've been fully informed about your specific situation. So, if you call the office and we do set you up for an initial consultation, it's not going to cost you anything to come in to have that first consultation with me to find out about your specific facts. Because, on these podcasts, I talk about the law generally. I don't give fact specific because I don't, obviously I can't in these situations. But if you want to come in, we'll sit down and we'll have that conversation. But as a general rule, you're better off having an attorney. The insurance company guarantee you has an attorney and people who are trained in Kentucky workers' comp advising them and making the final determinations. And they are looking out for the insurance company's interest. You need somebody who's trained looking out for your interest, whether it's me or another experienced workers' comp attorney. You need someone. If you've been injured, you need someone looking out for your interest.
Well, what I've always liked about working with you is you make it easy for the person. So that consultation could take place over the phone. That conversation could be maybe a video call, like a FaceTime call on, if you have an iPhone or something like that. But you also now have two separate offices here in Western Kentucky, which makes it even more makes it even easier, I guess, for the injured worker to sit down in front of you and have a good face-to-face conversation. Talk to us about your two locations.
Yes, I have locations here in Murray, Kentucky, where we're at today, at 509 Main Street, Murray, Kentucky. And I have an office in Hopkinsville, Kentucky as well, satellite office up there that is by appointment only there. Now, the office in Murray, you can drop in, but I'm probably not going to be available for a meeting right then, but you can drop in to schedule the appointment. Hopkinsville is by appointment only. It's 1910 South Virginia Street, Virginia Place. It's Suite 210 in Virginia Place there in Hopkinsville. But I also meet clients. Like you said, I do meet clients or talk to clients over the phone. I talk to them by video conference. But I also travel and see clients in other locations. Not too long ago, I was in Louisville on business and met with a new client at the hotel I was staying at. There, we met in the lobby of the hotel in a private little area there and met with that client up there. I go to Bowling Green fairly regularly, and I meet with clients up there. If you work for a union, I've used several union halls close to where the person works or the person is located to sit down and meet with clients in that setting from as well. So, if depending on where you're at, if we can do it by phone, but like on the one in Bowling Green not too long ago, I had to be in Bowling Green for a final hearing. And I talked to the client on the phone ahead of time, wanted to talk with them in more detail. And I was going to be up there the next week, and they were going to be available. So we used the union hall up there to meet with the client there, so that those things work well. And I usually am very open to meeting with clients in other locations if we can work it out.
Well, and that's the other thing that I hope people understand. You're licensed in the state of Kentucky, and workers' comp is state specific, which means you can handle workers' compensation claims pretty much all the way across the Commonwealth.
Correct. I've handled cases during my career. I've handled cases in as far west as you can go in Kentucky, and I've handled cases nearly as far east as you can go in Kentucky, and as far south and as far north as you can go in Kentucky. I've had clients in the northern Kentucky, Cincinnati area. I've had clients in Louisville multiple times, Lexington multiple times. Far eastern Kentucky, not as common, but I've had clients over in far eastern Kentucky, and obviously western Kentucky, where Christian County, Hopkinsville, Murray, Calloway County, where I'm at, where my offices are. In west of there, I have clients in all of those counties fairly regularly and on a routine basis.
Outstanding. So again, your website is jeffrobertslaw.com. You can find a whole bunch of information, a lot of these previous episodes we've referenced, that kind of information. But if someone just wants to call you up and say, hey, Jeff, I've been injured, I need to talk to you, can we set up a meeting? What's the best way for them to contact you?
Best number is to call 270-753-0053 or 1-800-844-5108. You dial either of those numbers, it rings on the exact same phone. So you can call either of those numbers to reach my office. At my office during business hours, you will nearly always get a live person. If everybody's on the phone line, then you may get the voicemail at that point, but it's very rare. Most of the time, you will get a live person answer that phone to talk with you, and then we can set up an appointment, get some information, and set up an appointment with you at that point in time. So.
Outstanding. Jeff, any closing thoughts? I mean, this has been 5 misunderstandings people typically have about workers' comp claims. I think we went fairly in depth. We referenced some other resources that people hopefully will take some time to listen to. But like I said, any closing thoughts as we wrap up the episode?
Just hopefully you won't get injured on the job, or you won't have a family member that's injured on the job. But if you do, let your employer know about that. And if you need medical treatment for that injury, seek medical treatment. My advice is to go to your family doctor first. If it's an emergency, you need to go to the emergency room, do that, or urgent care, do that. But otherwise, set up an appointment, go see your family doctor after the emergency room or urgent care, get them involved, let someone that you trust and know and who knows you do the evaluation. And if you need specialists, they can make those referrals for you from that standpoint. So let the employer know. Get the medical treatment for that, and then after you've established the medical treatment, give me a call, and then we can see what we can do for you.
Outstanding. Jeff, thanks very much for your time. And if you've been listening to us, thanks again for your time. I know there's a lot of things going on in your world as well, but you took out a half an hour to kind of learn a little bit more about workers' compensation here in Kentucky. So from all of us here at the Roberts Law Office, thanks for listening. We'll be back in a couple of weeks.
Thank you.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.